So welcome everyone. If you don't know me already, my name is Haruka Radobush. I'm the Senior Programs Manager at the Japanese Cultural and Community Center of Northern California, and we are based in San Francisco's Japantown. We're really excited to bring you tonight a special webinar on financial planning for your retirement. So if you're approaching the age where you think you're gonna settle down and retire, we definitely want to make sure that you are prepared. And we have two experts today. We have Laurie Shigekuni, a state attorney, and wealth advisor Lance Ichikawa to share with you today some general advice and information on things you need to think about to prepare for your golden years. And it's never too late or too early to start thinking about preparing for retirement. So whether or not you're going to retire in a couple years, you're already retired in some cases, or if you still have years of work ahead of you before you get there, this is still going to be relevant and useful information. Like I mentioned earlier, we are recording tonight's webinar. So if you miss any parts of tonight's presentation or would like to review any of the information presented tonight, please be on the lookout for the video posted to our website as well as our social media accounts in case you'd like to review or even share the information with others later. So with that, I would like to give a brief introduction to Laurie and Lance. So Laurie is an estate attorney at the law office of Laurie Shigekuni, Esquire. And so she will be presenting today on things pertaining to estates, wills, trusts, that sort of thing. And Lance is a wealth advisor with C2C Wealth Management. And so he'll be talking a little bit more about things like preparing your investment strategies in the current investment environment. And with that, I would like to give a disclaimer that the information that we're providing today is reflective of the viewpoints of the individuals presenting and not necessarily endorsed strictly by the center. And so any advice that you receive or any information presented in tonight's webinar should be taken as general advice. And certainly if you would like to make some financial decisions of your own, we encourage you to do your due diligence before taking any action. And certainly it helps to work with a professional that has a more direct knowledge of your personal circumstances and situation before taking any action. So with that, I would like to turn it over to Laurie and Lance. So thank you very much for joining us tonight.
All right, glad to be here. Thanks for having me.
Thank you, Haruka. Thank you, Haruka and JCCCNC for sponsoring this important event. So I would like to tell everybody that Lance and I have something in common. We both started at UC Berkeley in 1979. So we are both approaching like the retirement years. So we've thought a lot about retirement. I actually graduated from UC Santa Cruz in 1983, and then I went on to UC Hastings College of the Law, graduated in 1989, and I've been running my own estate planning, trust administration, probate firm for about 25 years. So my website is calestateplanning.com. You may look at that website for more information about trusts and wills and things like that. I'm a Sansei Gosei, and so going to Cal in 1979 was a really exciting experience for me because I was coming from a mostly Caucasian school, and so meeting a lot of Asians and Japanese Americans in 1979 was a really exciting time for me, and I started to explore more about my identity, and it was a great time, and I'm glad to have that in common with Lance. So I want to talk about trusts and wills and give you some of the basics. They're really important documents to know about and to consider having drafted. So I'm going to give you some of the basics. So I'm going to share my screen, and this information will be presented to you later by posting through JCCNC. But I'm going to share my screen and go over some of the basics for you, the nuts and bolts. Just one moment. Sorry. Okay, so we're at number 1, objectives. I'm going to talk a little bit about trusts and wills. I'm going to talk a little bit about the reasons to think about revising estate planning documents if you already have a will or trust. I'm going to explain a little bit about Medi-Cal long-term care because it's a component that might be able to be addressed through trust and durable powers of attorneys. And I'm going to talk about powers of attorneys and advanced healthcare directives.
Laurie, before you
Yes.
continue, seems like we're not able to see your screen share. If you could try turning that back on.
Oh, okay. I'm sorry. Thank you for telling me. Okay. Okay. Are you able to see it?
We
I
are
don't.
not. Let's see. Let me see if I can change some settings here. Okay, let's try that again.
Okay. Okay. Do you see
There
it?
you go.
There we go. Yep. Great.
Okay. Great. Okay. So the trust is a key element for estate planning documents. They started becoming more popular in the 1980s when people started having personal computers. They've been around for a really, really long time, but it wasn't until the personal computers started getting more prevalent that ordinary people were able to start affording them. I want to tell you about the 4 parties involved in the living trust so you get an understanding about what a trust is. So the first party is called the settlor or the creator. That's the one that has the trust written. So for my husband and I, we are both the settlers of the trust. The second party is the money manager of the trust. This is the trustee. So for my husband and I, we are both the trustees of our trust. The third party is the successor trustee. That's the one who will take over after both my husband and I are unable to act. And the fourth party is the beneficiary. That's the one who will receive the assets from the trust after both my husband and I pass away. And so in our case, that's our 24-year-old son. So one of the reasons why people get a trust done is to avoid probate. So probate is a process that happens in the superior court, and it's generally a good idea to try to avoid it because it's time consuming and expensive. And so trusts are kind of the estate planning method of choice these days. On my website, I have an article called Trust versus Wills. And so you may go to calestateplanning.com and read a little bit more about trust versus wills if you choose to. So your estate would go through probate if you have a home or any real estate worth more than $50,000 or assets that are not in pay on death accounts or joint tenancy accounts that are greater than $266,500. So one of the things that's really intertwined with estate planning are taxes. And so over the years, the estate tax scenario has changed dramatically. When I first started practicing this area about 25 years ago, the amount that one person could own and not have to incur any federal estate tax was only 600,000. So now that amount has really jumped up. So through the Trump tax laws, there was a revision in the tax code. And so right now, one person can own 11.7 million and not have to incur any federal estate taxes. So what this means is that people who had trust drafted a while ago would really be advised to talk to an attorney about their older trust, because sometimes things could be made a lot simpler, and there is good tax reasons and just personal preference reasons to take something that was drafted in light of the older tax exemptions and update it. So there's going to be a lot of changes in the future because the Trump tax laws sunset in 2026, and it goes back down to about an indexed amount of about 6.5 million in 2026. And then Biden's thinking about making some revisions to this tax again. And so under trust for married people, if you're a married person, my website goes through some of the tax changes over the years. And you could see some of the reasons why people may want to like re-examine some of the older ways of drafting a trust and simplify it now. So the other tax involved with estate planning is the unlimited marital deduction. So spouses are able to give things to a U.S. citizen spouse, and there's not a tax that has to be paid when the first spouse passes away. The tax is deferred until the time that the second spouse passes away. There are things in the tax code now that make it very important if one spouse passes away to speak with an estate planning or a tax specialist, because there are things to act upon after one person passes away that you may not be able to act on if you wait too long. For example, there's a 2-year limit for one surviving spouse to claim an unused exemption for a spouse that passed away. And as I was saying, there is an 11.7 limit this year for each person who passes away. So if there's a death, then that person who died was entitled to an $11.7 million exemption. So the person who lives would be well served to try to claim the unused exemption. So the other tax that comes into play when somebody dies is the capital gains tax. So that's the advantage that somebody has after a person dies. Then there could be a step up in basis. That means that something that was purchased many years ago, like a home that was purchased for $300,000, if there is a death, and for the if there was a death, then that whole home gets reappraised upon the death. And so if it's sold, then there's not a capital gains tax. For community property, then it's as if both people in a married couple own the whole property. So if something is properly characterized as community property, then the whole asset would be reappraised when one person passes away. So it's a good reason for married couples to get estate planning done, because it's important to properly characterize things as community property, because there's a huge tax advantage of getting a step up if one person passes away. So the advantages of a living trust is that you're able to direct who you want to receive assets after you pass away. Again, there's no probate if everything is properly placed in a living trust. There is the estate tax reasons for like seeking estate planning advice, because it's kind of tricky about like claiming things in 2 years, like I mentioned, and just trying to think about the various taxes that come into play when there's a death. The other reason why a trust is a good idea is that it avoids a process called conservatorship. So conservatorship is a process that happens in the Superior Court, and it's a way so that the court could appoint somebody to take charge of financial decision-making and healthcare decision-making in case somebody loses capacity. So with the estate planning process, there is a way to allow somebody to make health or financial decisions for you in case you have a stroke and you cannot, you can no longer handle things on your own. So the things that are in the trust, as I mentioned, there is somebody called a successor trustee. The successor trustee would be able to manage things in the trust, even if it's for a temporary point in time, in case there's a loss of capacity, so the assets can be managed properly. The other reason is that you're able to retain the complete control of your assets, of the things that are in the trust. And for children or for grandchildren, if you have things in a trust, then you can have a trustee be able to manage money for the children or the grandchildren. And the children or the grandchildren are not responsible for holding the purse strings, so that more money can be conserved until the children or the grandchildren reach retirement age, and money can be given to the children or grandchildren. So the disadvantages of a will versus a trust is it costs a little bit more to set up a trust than it does to set up a will or to do things in joint tenancy. And it does require some work of putting things into the trust. So if you have an older trust, there are reasons to have it examined, because the older way of having estate planning documents done was to have one trust set up upon the death of one person in a couple. And so if one person dies, some of the older trusts set up a bypass trust. And so the assets are split in 2 different halves when one person passes away. So those trusts were more commonly done when the estate tax limit was lower, but now there's a simpler way to draft things. And the other reason to have estate planning work done is because of HIPAA laws. The privacy laws have changed very dramatically over the last couple of decades, and the timing of documents can be examined because of the way that privacy laws have changed. It is possible in powers of attorneys to write statements just about how you wish to be cared for if you need more help. So in the estate planning process, the lawyer tries to raise all of the things that are really hard and awkward to think about all in one time. And so it's kind of difficult, but it's important because you're able to address things like what happens if I have a stroke? What happens if I need convalescent care? There's just ways to talk about things and deal with them. So a note about long-term care, Medical is the only program that will cover catastrophic care like nursing home care. So there was a tragedy in my personal family not too long ago, and a family member needed convalescent care, and it's like $12,500 a month. So it's really a strain on the family. Medical long-term care is the only program that will address these needs. And there is a way in powers of attorneys to just build in more flexibility. So if something happens, you're allowing the possibility for estate planning documents to be changed in case you can't sign your own documents, and for some more extensive and complex gifting to be done. So that was a lot in a very short amount of time. So thank you for your attention. I will turn the floor over to Lance.
Okay, I don't have any things to share on the screen. I do want to say sort of how Haruka did his disclaimer. I'll have a disclaimer as well that, it's financial planning for retirement in 15 minutes. It ain't going to happen. And I had written down notes more about, the current financial environment for retirees. And as you all know, especially if you've gone to your bank recently trying to get a CD, that interest rates are extremely low. And in some parts of the world, they're even negative in Europe. And so that puts a lot of strain on the planning for retirees or people who are about to retire. And, there used to be a rule of thumb for portfolio management that basically take your age and that should be the percent of bonds that you have in your portfolio. So if you're, say, a 30-year-old, then you should have only 30% in bonds and 70% in stocks. Or if you're more like me and 60 years old, I should have 60% in bonds and only 40% in stocks. But because of the extremely low interest rates that we have in the environment right now, that makes it almost impossible to stay with that kind of an old rule of thumb. So, what's been happening a lot is that basically a lot of money managers we're taking a lot more risk with our portfolios, more than we might be comfortable with just because of the current environment. And what I mean by that is, for my retirees or people soon to retire, I'm holding a lot more stocks in my portfolio than I would normally be comfortable with. And, that can lead to problems, obviously, if the stock market goes down. And people are trying to take money out at the same time. So it's been a real tough environment right now, and basically since the great financial crisis, in 2008, where we started having these low interest rates. So when it comes to, so the idea of financial planning, I would say that, first of all, if you do hold a lot of stocks, probably more than you might be comfortable with, you're in the same boat as many of us are. I don't know if that gives you any solace at all, but one thing to watch out for, in this environment is that we are at extremely high valuations in the stock. It's basically overvalued. If you want to use different metrics, there's a Buffett indicator, which is like the GDP or the total stock market value over the GDP. And because we're at such a record level high that the Buffett indicator would say that you should expect a return for the next 8 years of negative 3.1% per year. John Hussman does some work, and he's saying that with his analysis, you can expect a negative 7% per year for the next 12 years. There's several value-oriented analysts who are warning about the high valuations. And, so that puts certainly a lot of strain in trying to plan for anybody in retirement. And, when I say this negative, 7% or negative 3% per year, that's an average, right, per year. And what is significant is, the series of how you get to that figure of, let's even take the negative 3.1%. It doesn't, stock market doesn't work where every year it just goes down 3.1%. Usually there's a large drop and then somewhat of a recovery in that long of a time frame. And it really matters if that large drop comes at the beginning of the time frame or at the end, particularly if you are retired and you're taking money out of your account when the stock market goes down. Then really impacts and impairs your returns for the remainder of that time frame. So it's been really difficult planning around for retirees, and it's as you can see by those figures, it's going to continue to be difficult because of where we are right now in terms of valuation on the stock market. And like I said, when you look at what we get, the 10-year Treasury, U.S. Treasury was still under 1.5%. We were at 1.75% not long ago. but we're back down to 1 point or less than 1.5%. And the 30-year U.S. Treasury bond went below 2% briefly, I think, on Monday, and even then we're still at only 2 point some odd percent. And those are safe investments, safe long-term investments, which we used to be able to use as advisors as sort of a benchmark that, if nothing else, you chunk all your retirement money in a 10-year U.S. Treasury or a 30-year U.S. Treasury. You used to be able to get 5 or 7%, but these days you only get 1.5 or 2, which is less than inflation. So you are going to be losing buying power throughout that time. In fact, there's also used to be another rule of thumb for your retirement assets that once you hit retirement, you can take 4% out per year. But that idea or that rule of thumb was developed during a time when the 10-year Treasury was over 5 or the 30-year was over 7. So that rule of thumb is kind of out the window now because you will be eroding your assets if you do take that much. Unless you are invested in the stock market, and and there are safer stocks. Zoom Communications is obviously a high growth stock that is overvalued by some metrics, and that's not a recommendation, by the way. And there's also things like, or on the other hand, there's things like Verizon Communications, which is more of a dividend yielding stock, which is theoretically safer because it isn't quite as overvalued, but still they're overvalued. And basically, as we saw in 2008, and certainly last March, even that, when the market goes down, everything goes down. And so it's there's really no safety net per se. And so you just really have to be careful. And, and the thing I would say that if you are invested in stocks right now, don't do the mistake that my friend just told me about. He was extrapolating last year's returns in his IRA, which, luckily for him, it turned out to be somewhat 20%. And if you start extrapolating that out, he said, yeah, I'll double my account in 3.5 years and, be quadrupled in 7 years. And, when you're at a near a top or near a peak in the stock market, when you start doing that kind of extrapolation, that just starts to get to be room for a lot of mistakes happening. So you really have to just be careful. I certainly would say in this environment, if you are nearing retirement, as some of you mentioned, just look at what you're invested in. And a lot of times, when it comes to investing, it's really trying to understand yourself and what they say is your risk tolerance. And so look at the value of your accounts and say, how would I feel if this was 20% lower? How would I feel if it was 30% lower? If it really makes you uncomfortable, then you probably realize you should do some changes in your account if you have a lot of stocks. And it is my wife tells me don't be such a Debbie Downer, but that's just where we are. That's just sort of the reality of where we are right now. And you really have to pay attention to what you're invested in right now, because it could get worse, but it could stay high and go higher. When I say those figures too about -3%, -7%, these analysts are long-term analysts, or their time horizon is very long-term. It's only one thing that we learned in the 99-2000 .com bubble is that the market can go a lot higher for a lot longer than you expect. And just because these analysts say that that's what you can expect in a long-term time frame, it's not a timing mechanism. It's not something to be used to say, well, boy, if I hear that, I'm going to start selling right now. No, it's just meant to be a shot across the bow, if you will. It's something to warn you that things might change, and we are so overvalued right now in the stock market that it might be time to start changing your asset allocation, how much you have in stocks, how much you have in bonds. And there are other indicators, anecdotal indicators of frothiness of this market. Back in 1999 is obviously the .com bubble, and all the .com companies that were coming out left and right and just going to the moon right away. Right now you can certainly look at things like Bitcoin or Dogecoin or NFTs or these the SPACs and the new iteration of IPOs coming out, where you're seeing a lot of frothiness in the market, and that should give you a little bit of a sign of a warning that you gotta kind of just be willing to either ride out the storm or change your investment allocation right now. So and I'll tell you something, just in terms of success or planning. I actually came across this book at from the local library, and it's pretty good when it comes. And the name of it is Your Complete Guide to a Successful and Secure Retirement. It's by Laurie Shigekuni and Kevin Grogan. I was pretty surprised at how good it is. And if you want, actually, maybe I'm not, I'm showing the title here, but I'm not getting any royalties or anything off of it. But I was really surprised at how good this book is, going over the different aspects of retirement planning. And not just the strictly financial part of it, but some of it emotional part of it, and goes into insurance and real estate lightly. It's fairly easy to read too, so I would recommend you picking up a copy of this at the library and maybe taking a look at that. So and so just in general, I certainly at when we talked about doing this webinar, me blathering on about the markets or trying to tell you about financial planning within a 15-minute time frame is difficult. And I think probably the best use of the time would be to answer questions. And my compliance department doesn't want me to. I couldn't have a set presentation because it has to get approved by compliance, or handouts has to get approved by compliance. But if somebody has a question and answer it, then that's something that's because of the freeform nature of that, I can easily do that. Actually, I see something. I'm looking at the chat. I want to have the name. The name is can you see it? Your Complete Guide to Successful and Secure Retirement by Laurie Shigekuni. Okay, this is being recorded, so I'm sure you guys can look at that up again. So anyway, with that, I think, certainly the time we have. Does anybody have any questions, or Haruka, do you want to take over again?
Sure. So I think maybe I'll open it up with a question for both you and for Laurie. And so my initial question, I think, in terms of thinking about preparing my retirement, one of the first things that I've come across in my own research is that people have pointed out different ways of calculating sort of an initial amount that you should plan on having saved up or accumulated in assets for your retirement. Are there any sort of general guidelines that you have for people to figure out that amount and from there work towards like figuring out how much every year they need to be putting towards that amount?
I'll take a stab at that one. General rules of thumb, you need 80% of your income in retirement. So calculate what that number would be, 80% of your income. And then what I would do is using something like the interest rate of the 10-year US Treasury, which is 1.5%. And use that kind of as benchmark as to what kind of return you can get. You can figure out how much assets you need by using that income. You have your income, 80% of your income, and then if you use the 1.5% on the U.S. Treasury, you can do an equation so you can find out how much in assets you would need at 1.5%, right, to get that income. So that would be a base, and that's just spreadsheet usage, no fancy financial planning or financial plan or Monte Carlo simulations, and it's just basic arithmetic. And that's what I would suggest doing, just as a ballpark. Obviously things change, and that 80% figure, another rule of thumb. I don't know if that's good or not anymore, but for me, it's you know, the more the better. But Laurie, you got something?
Well, one thing to keep in mind is that there is a safety net. And so one of the things that helped some of my clients to be a little bit more at ease about is just learning about the long-term care safety net we have. Because some people think that Medi-Cal long-term care is something that they could rule out, because Medi-Cal is generally thought of as the program for poorer people. But for the case of middle income people, it's a very generous program, because there's certain assets that are exempt assets. So the home is an exempt asset. And that's a huge exempt asset because our homes are worth so much in the Bay Area. The other asset that can be exempt is retirement accounts. And so for the case of couples, the retirement account for the person who is the well spouse is not counted when the sick spouse needs some convalescent care. And for the sick spouse, even, the whole, the lump sum of an IRA or a 401k can be considered an exempt asset if the person is taking withdrawals of income and principal. And so at 72, you have to start taking withdrawals of income and principal anyways. So having those rules about like the home and retirement accounts, which are some of our largest assets, like being permissible assets, and then having some good estate planning and powers of attorneys in place in case there's a catastrophe, just to know that there's a way to get help through the state and federal government could be a little bit of a relief.
Right. Thank you. Laurie, I actually have a question that's pretty similar to the one I asked Lance regarding sort of calculating a certain figure, but I'm curious as to at what point, is there like a threshold amount that people should have in their assets before they really should consider contacting an estate attorney to start setting up trusts or their estate?
Well, any person who owns a home should really have a trust. Mm-hmm. Because if you have stocks and bonds or bank accounts, there are ways to do beneficiary listings at your financial institution or at your bank. And so you can't have as much complication in a beneficiary listing, because in a trust, you could go through a lot of different contingencies. Like if somebody dies, what happens? If that person dies, what happens? So you can go over like 50 years, you know, of contingencies so that things are in place. But through simple beneficiary listings, it's possible to have more complication built in, but you kind of need a lawyer to just build in more complications. But with a house, it's a better idea if you have a trust. So for married people, you can have things, community property with right of survivorship. So if you don't want to invest in a trust, it is important to look at your deed and make sure that things are listed the right way. Because if it's not listed the right way, if it's joint tenancy instead of community property, if one person dies and the house is sold, then there's a big hit you would take in capital gains tax that you wouldn't have to take if you had your deed listed the right way. And so like people think they might be just doing themselves a favor by just having the deeds drafted in a quick way without the advice of a lawyer. But what you don't realize is that with any deed, there's tax implications once the property is sold. So if it's drafted in a preferable way down the road, if there's a death, you could really save money. And so for home ownership, I think it is really important to have a trust, or at least be consulting with a lawyer just about the ways that property's held. Like if you decide to just like add a child like onto your home, it could be a negative thing for the child, because there could be tax advantages to just having the child inherit property instead of having it be listed, having the child be listed on the deed. And there's a risk because if your child gets into an accident, the home is one of the assets that they own. And so it could be subject to recovery in a lawsuit, you know, if the child's part of the deed. So that's the general rule of thumb, I think.
Thanks, Laurie. All right, so I'd like to open it up to the audience as well. If you have any questions for Lance or Laurie, please put them in the chat and we can read them out loud for them to answer. And so we'll give you guys a couple seconds to put in any questions that you might have. But if not, then I do have a follow-up question for both of you guys in case we don't get any immediate questions from the audience. And that would be, in the course of your work, you know, as a wealth advisor, Lance or Laurie, in terms of working with your clients, are there any common pitfalls or mistakes that you've seen that you would advise people here to avoid?
Well, I would say that one thing is, and you know, actually, Laurie brought up a good point about the protection of the IRAs or the assets in IRA, and it's a good place to have assets because it does get protected in certain ways. And I would say one mistake I see clients make all the time is when they look at their retirement accounts, IRAs, 401ks, whatnot. You have to realize, because you will be, you know, not a Roth IRA, but all the other ones, you will be paying taxes, income taxes, when you take money out of those accounts. So when you look at the value of your IRA, you got to kind of think it's actually about, you know, to be conserved, 30% less than what you see. So you know, you might think that, hey, you're in a good spot right now, but you know, keep contributing if you can, keep building up that IRA, because the government will take away you know income taxes from that. So that's just kind of one of those things that I have to remind my clients all the time, that hey, you know, your value is this, but don't forget Uncle Sam takes 30% of that, so we have to keep building it. So it's one thing off the top of my head.
So I think that it's a better idea to consult with your estate planning attorney my general rule is 3 to 5 years. Generally, people don't consult that often. It might be 5 or 10 or 15 years, but I think just keeping an eye on your trust is important, because the laws do change and because it's easy to forget to put assets in the trust. And so more work needs to be done by your survivors if you don't have all of your assets in the trust. And so just investing a little bit of money in consulting with a lawyer and looking at the ways to do the documents and to have the assets funded in the trust is a little bit of an investment in time and money, but I think that it could save your family or your friends a little bit of difficulty in the future. And the main thing is just to get documents done. You know, it's just kind of it is a little bit difficult, but it's well worth it because it just helps if there's an illness or an accident. And so I think the main advice is just, you know, if you haven't done documents, it's just a good idea to do them.
Right. Thanks, Laurie. We actually do have a couple questions that have come in from the audience. So we'll start with the question from Pauline, and this is for you, Laurie. She asks, what is your opinion for Prop 19 purposes? Her husband and she changed title to their home from community property to TIC with their 2 children. So are there any risks in changing title? Actually, there's through multiple deed changes, they went from CP to joint tenants, not TIC, with their 2 children. So now they're all covered, or they're all considered original owners. So were there any risks associated with changing titles in that process?
So it is a complicated question because Prop 19 was the law that went into effect in on February 16th of this year. It was passed by the voters last year, and it changed the way that property taxes are calculated. So before, property that passed from parents to children didn't have an increase in property tax when there was the death of the parent. But with Prop 19, there is still a exemption from parents to children. But now there's the extra requirement that the child within 1 year has to claim that they are having that home that they're inheriting as their primary residence. And the parent must also have lived in the home. So right before the law went into effect, there was a lot of changes. There was a lot of work that people went through to try to have the property tax basis stay low for the children. And so some of the things are still just a little bit unsettled because it's a little bit of a new area. So lawyers were consulting, were really coalescing together in Facebook chats and in just different conversations because all of the counties in California were handling things like a little bit differently. And so it was difficult to get a read on what some of the, how things would pan out. Because the issue is that if a gift is made, then the person who receives the gift receives the basis from the donor. So when a gift is made from the parent to the child during lifetime, the child gets the basis of the parent. So that could be the purchase price plus the increases of basis as different improvements are made to the property. Whereas if people are receiving property as an inheritance, when there's a death, then the child receives the stepped up basis of the parent. And so it was a individual conversation that we had with people about what the basis was and if there had been a death of one parent, because when there was a death of one parent, there could, there was some step up in basis. And so it's a very individual decision about the particular property, what the value was when it was purchased, and what the value was when one person passed away, and what you would be losing as far as capital gains tax go, and what you would be preserving as far as property taxes go. Like if one child was thinking about moving into the property, or if the property was going to be sold, you don't have to worry about it at all because the property tax, isn't going to be an issue. And so for your specific question, I'd have to look at the values. But it is, a weighing and balancing type of thing that's kind of difficult.
And I'll throw in, I'm getting out of my lane here. And so this is not tax advice, but having looked into it myself, a problem with signing over, I guess in this situation, 1/4 of the property's value to each child, it was under my understanding that there'd be gift tax consequences as well, because you are basically, if you just put your 2 kids on the title of the house, you are gifting 1/4 of that value to those children in that one fell swoop. And so consult your tax advisor.
So with the gift taxes, you just have to know that next April, you have to file a gift tax return, just saying how much was gifted. And so that means that you have less to give away when you pass away, but it just comes off of the value that you have as your exemption from the estate tax. And the estate tax is so high right now, like it's 11.7 million right now for one person, as I was saying. And the indexed amount in 2026 is scheduled to be about 6.5 million. So you file a return, but you don't actually need to file a tax. You just have, it's like a credit and debit system, it's like a debit system. So it chips away at your estate tax amount. But if things keep going the way they have been, your amount is so high that you register the amount, but it is likely not to have a real implication.
Yeah, there won't be a financial impact, but file that form. Don't forget to file that form.
Right. Yep.
Great. Thanks. So our next question is from Jennifer. And I think this is probably going to be more in Laurie's wheelhouse. But Jennifer's question is, her brother is the sole beneficiary on her trust, but she wants to know how she can change her trust to include his children, but not his wife.
So actually, that's a very common estate planning choice. So most of the time, when people do estate plans, the direct descendants are included in planning. And if you don't have a will or trust drafted at all, the California, what's called the intestacy law, which is the law about what happens if you don't have a will or a trust, is to lineal descendants. It doesn't include spouses. And so there is a way to draft things that will take into consideration a gift to your brother's lineal descendants or to his children. And so you could write it in so that you say, to my brother, and if he fails to survive me, then to his issue by right of representation. And so that would cover like children he had, and if a child of his passed away, it would like go on to that deceased child's children. So there is language that could be put into your trust to cover that situation. So trusts are very commonly called revocable trusts, because as long as you have sufficient capacity, you could change your estate planning documents at any time. So you can have your trust changed so that if your brother passes away, it could go to his lineal descendants.
Right. All right, and it looks like we have a quick question. I think this is from Gerald, and he's asking, are you both taking on new clients?
Yes. If they want to reach, you have my contact information, right, Haruka? So if they want to reach out, you could do it through you.
Okay. Yeah, certainly I'll provide both Lance and Laurie's business contact information to everyone following the program, along with the link to the video recording of tonight's session, as well as the printout that Laurie had on screen earlier as well.
Yes, I am accepting new clients as well.
Okay, great, great. I have a question I think that maybe Lance can answer, and that's regarding liquidity of assets. So as people approach retirement, is there anything that they need to do as far as managing their assets to make sure that they're more liquid, or if they need to, like in an emergency, make funds more readily available in their retirement?
I would say no, there's not really a need to shift your asset. It's kind of an asset allocation question, how much you have in stocks, how much you have in bonds. And generally well, I guess maybe yes, the answer is yes, because you generally have more in cash, and in cash should always be part of a portfolio. And as you get older, if you're kind of using the whole rule of thumb that I was talking about, if you're 60 years old and you have 6%, supposed to have 6% bonds, you may not have 6% bonds, but you might have 10 to 20% in cash anyway. That always acts as a ballast in your portfolio. It's kind of the steady as you go, you're not going to lose it portion of your portfolio. So generally speaking, as you get older, you tend to have more cash or more bond-like investments. And and frankly, if you do have bond-like investments, it's probably short-term bonds. I don't think I have anything over 5 years right now. And so it's readily changeable into something or into cash if you need to take out. So I guess I would say that in general, you are already changing your asset allocation in that direction already. So there's no need for one huge fell swoop of liquidating things unless you are a high-tech person and you got all your money in Google stock right now and warrants. You might want to consider diversifying. That kind of idea.
Okay.
So,
We have any other questions from the audience at this point? No? I have a general question then for people that are interested in retaining the services of a qualified professional like yourselves. What sort of timeframes are we looking at as far as the process of setting up, say, like a trust or an estate, or how actively do your clients need to meet with you to manage their assets, Lance or Laurie?
you want to go first, Laurie?
Okay, so a lot of our newer clients are starting to have their things done through our seminar model. So we gather about once a month in the late afternoon, a combination in person and Zoom. And for a couple of hours, we cover all of the basics. And we're able to do a flat rate because people do a lot of advanced thinking and are able to meet with me for about 1 hour after that. Me or one of my associates. I have other attorneys that I hire, and then schedule another meeting time after that. So it could be as fast as like a couple, 3 months. It's a lot of times longer because people need a little bit more time to think. So we can turn things over in a month or two. If people are really dedicated to just being proactive and processing through a lot of information. But it could take, 3 to 9 months because usually people need to think a lot, and process through things. And with people's schedule with kids and with, vacations, it just takes a little bit longer, but it's not that long.
Laurie's talking about me because I am using Laurie's services for establishing a trust, and we're busy, and all of a sudden we had to cancel our appointment last week because my wife was a little too busy to go in. So now it's put off for another couple of weeks. And it's like, a lot of times you just get busy, and it shouldn't take as long as we're taking. But Laurie is very thorough and efficient about keeping us on track. So, so that's that. So for me in my practice, when it comes to timeframes, it's just opening an account is real quick, and then generally speaking, it's a matter of transferring accounts from other brokerage firms or whatnot. And my firm custodians all our accounts at Charles Schwab. So and that means that all our accounts that we have we open in a Charles Schwab account, but we are the managers over that account, and it's through the Charles Schwab institutional department. And so that is obviously pretty quick. And then even when it comes to transferring in an account or transferring from another firm, but when it comes to the planning part of it, it does take a while just to be able to sit down and talk. These days, I guess it's going to be mostly done off of Zoom, and to find out, it's my job to kind of find out everyone's risk tolerance, and I'll tell you, I'm a little rusty with that when it comes to mass marketing accounts, because most of the accounts I open now are all referral based, and so I kind of know the person just through the current client and whatnot. But it would take me a while to get to know what your personal risk tolerance is, and what your plans are, and things like that. And then after, and one thing I didn't say in this planning process is that it's one thing I certainly don't like about the written financial plans you find a lot of people doing these days, and they just kind of spit them out and then hand it over to somebody and say, there you go, here's pay me $2,000 for that financial plan. Financial planning it's a living and breathing organism. I mean, you have to kind of stay on top of it, stay with it, and it changes. And so what I'm saying is that even though you might have a plan in place, you might have an idea of what you want to do, but it changes because of not just your own personal life and what's going on in your life, but what's happening in the markets. And certainly with what's been going on in the markets, as I was alluding to earlier, it's changed a whole lot. And so it's a constant development where you are always working with your clients. And for me, it's supposed to be once a quarter in terms of meeting, setting a meeting. And frankly, for most of my clients now, they would rather not hear me that much. And so it's gone to like, 3 times a year down to like 2 times a year. So, hey, Lance, annual is fine. We don't need anything more than that. So, and that's really up to each individual client and, how well I know them, how well they know me. But in the beginning, I would probably recommend, once a quarter meeting just to see what's going on. And also and frankly, when it comes to, the updates, I'm always available via email, a phone call and whatnot that, things could change all the time. So timeframes, like I said, opening accounts, transferring in assets, 3 weeks, but the rest of that time it's going to be a lot of just, getting to know each other. Frankly, you should get to know each other before you sign up, because that's, that's the way to do it. But anyway.
Due diligence is always important in all aspects, right? Okay, so seeing that we don't really have any further questions from the audience, I do want to ask one final question for both of you guys. And I think this question invokes a little bit more of, or it'll draw upon your, I guess, cultural familiarity with attitudes towards money and wealth management within our Japanese American community. But generally speaking, yeah, wealth, money, taxes, debt, those are all very sensitive subjects, right? And, these are big decisions that a lot of us have to make, and it'll involve more than just ourselves, right? It'll involve our family members as well. So do you guys have any advice on how to broach the subject of your financial planning with the rest of your family? To what degree do you want to have them involved, or do you advise keeping them out of sort of the planning process until it's all said and done and decided? What are your pieces of advice for the community on those fronts?
Go ahead, Laurie.
Well, my advice isn't in like talking about money, because I don't deal with transfers of money. I deal, the issue comes up more for me in the areas of settling estates, because I've heard from some of my clients that people are getting into disputes just about receiving money from aunts or uncles or parents. And so I've just observed one cultural thing in the Japanese American community is that we're very conflict adverse. And so I think it comes from our incarceration period. Like people just, like our parents and grandparents just had to deal with life by putting their nose to the grindstone and like just not talking about things. And so I think that in our interpersonal relationships and as problems arise and there's like money on the table, sometimes our cultural trait of like not dealing with conflicts very directly like becomes an issue when there's problems, because we're not as skilled about verbalizing things. And so when I'm trying to settle estates, I just talk about relationships and team building and trying to help people see the other point of view and think a lot just about preserving relationships and communication.
Yeah, I'll throw in there about the, settling estates aspect where, I've heard a few cases now where Japanese American families are having issues in settling an estate, and there are arguments and families being ripped apart, which you always think, it's Japanese American, no problem there. Everything's quiet and held inside until what hits the fan, and then it all starts flying all around. And I think that using a third party, a professional, like Laurie, a state lawyer, and particularly if you start the process, and then as an example, if I start the process and my kids are older adults, let them know, hey, I'm talking to an estate lawyer now, and that kind of starts putting the idea in their head. If you got anything to say, you better say it now, because it's going to be put in a trust soon or whatnot. And that might start the conversation, or at least allow the ability to start in a conversation with the family. Because I do believe as well that when it comes to the Japanese American communities, it's a tight-lipped thing. And as my mom would say, no need no. It's just basically, right. Hey mom, what do we got? No need no. So it's like, it's basically butt out. It's none of your business. But when it comes to the planning aspects of these things, you start doing it now. And one thing I didn't mention too is like the idea of gifting. It certainly helps, especially if you have large assets, a large amount of assets. Start gifting away now to relatives, so that your estate tax burn down the road isn't that great. And also just for the sake that the beneficiaries might be able to benefit from it now while you're alive. But I'm telling you, that's not a topic that anybody wants to broach when it comes to the Japanese American community or Asian American community. It's so tight-lipped, and you would think that as we get older or get more Americanized, that might change. But I don't feel that much change. There hasn't been much change at all. So enlisting the likes of Laurie as a third party professional, and to be able to start a conversation, just say, I'm not saying that drag Laurie into it, but just say, we are talking to, and that might open up the conversation. So I would say, do it that way.
Great. Thank you so much, both of you. And yeah, speaking of gifting too, the Center as a nonprofit organization is always happy to be bequeathed money in people's estates. If you want to leave a little bit behind for the community, we'd always appreciate that as well. But certainly that's something that you will want to talk to an estate attorney about to make those sort of arrangements. But in any case, I want to thank you guys again so much for sharing your time and your expertise with the community here tonight. And I do expect that people will probably come away with this session with some additional questions that come to mind after we're all done here tonight. So we'll certainly include in my follow-up to all the registrants tonight your contact information, so that they can get in touch with you if they have more specific questions about their personal situations. And in the meantime, I do want to remind folks that the center is now reopened since our pandemic closure. So it's been great having our programs back at the center and having people come through our doors again and seeing all those familiar faces. So if you're here in the Bay Area, please do stop by when you can, say hi, and take a workshop or a class with us. And in the meantime, we do hope that you all are staying safe and healthy, and are doing well in your plans for your own retirements in the future. And hopefully maybe we can bring Laurie or Lance back in the future for some additional informational sessions, especially if you have questions for them or ideas for topics that you would need some sort of professional advice on that we might be able to provide for the community. So with that in mind, thank you all again, and please have a good night and take care. Thank you.
Okay.
Thank you very much,
Thanks for having
everybody,
me.
for your attendance. Thank you so much, Haruka, for the good work that JCCCNC does.
Absolutely. Thank you.
Thank you very much.
All right, good night, everyone.
Good night.